Everyday injustice.
Today on Everyday Injustice, we have guests from the Duke Wrongful Conviction Clinic, and we are going to be discussing the case of Andrew Junior Chandler, who was convicted back in 1987, coming up on 34 years this month for a high-profile series of child molestation cases, and we'll get into the details there. But first, I want to have our panel introduce themselves. We'll start with John.
Hi, thanks for having me. My name is John Sack, and I'm a second-year law student at Duke, a member of Duke Law's Wrongful Convictions Clinic, and I'm one of the students that's been working on this case this semester.
And we'll go to Meredith.
So same from me. Thank you for having us. I'm also a second-year law student at Duke Law in the Wrongful Convictions Clinic and the other a student assigned to this case for the semester.
And Theresa.
Hey, hi, David. So Theresa Newman. I am one of the directors of the Wrongful Convictions Clinic, a lawyer, trained at Duke Law School. So I'm a Duke graduate. I've been working on this case for quite a while. And each semester, or each year, we add more students to the clinic. So John, to the case. So John and Meredith are our current students, and we are so grateful to have their help.
And Jim Coleman.
Hi, David. I'm Jim Coleman. I'm the other co-director of the clinic, and I've been sort of consulting with Theresa during the time that we've had the case, but I have started to play a more prominent role this semester.
And Dave.
Good afternoon. My name is Dave Martin. As indicated, I'm a retired attorney from upstate New York. Practiced there for a little over 40 years, primarily in business and commercial litigation. I've been interested in the Innocence Project for a number of years, and I think it was a little over 2 years ago, I contacted Duke, and Professor Newman responded very, very quickly and said, quote, they would accept, end quote. And I said, what do you accept? And they said, well, any volunteer work that I'd like to provide. So I've enjoyed it, and they're interesting cases.
Well, welcome everyone. So this case is really interesting. I've just been able to dive into it in the last few days. And it's kind of interesting the way this kind of came down. So the first trial in this case ended with a hung jury in February of 1987. And, instead of waiting several months to retry it, they did it almost immediately the next month in March. He ends up getting acquitted on some of the charges, and then he gets convicted on 5 counts of first-degree sexual offense, 6 counts of taking indecent liberties with a minor. I've never actually heard that charge described that way. And 1 count of crimes against nature. And for that, he's sentenced to 2 consecutive life sentences. And just because that's not enough, they add 21 years to it. How does he end up getting a double life sentence out of all that? I'm trying to kind of untease how this all works.
Oh my goodness! So I'll tackle that. And one thing you didn't cover in your short procedural history is that it was tried a month later in a different district. So the very, very unusual for the state to move for a change of venue. Change of venue usually occurs when it's requested by the defendant because he can't get a fair trial because of press coverage or for other reasons in the county in which he's tried. But in fact, North Carolina's statute doesn't even contemplate the state, the prosecution, moving for a change of venue. But here, the prosecution moved, and in the court's inherent authority, in the interest of justice, moved it to a county, to a different county. And the state the reasons for which they wanted it to be moved is because Junior had too much, we call him Junior, he is Andrew Junior Chandler, I'll call him Mr. Chandler, but Mr. Chandler had too much support in the county because he was very well known. It's a small rural county north of the county in which Asheville, North Carolina sits. A lot of listeners or viewers will know Asheville, kind of a hot tourist place. And it's just a small rural town, and he was well known and respected. So the state, the prosecution felt they couldn't get a fair trial and moved it to another county. So on the sentences, you know, it's funny because yes, 2 consecutive life sentences plus 21 years. I sometimes think he was lucky he didn't get much more, because the cases that arose in that period of near hysteria and child sex abuse cases in the United States and around the world. I think another famous case in North Carolina was the Little Rascals case, and he was convicted on 99 counts, the owner of the daycare center, 99 counts. I can't remember how many life sentences he received, but Mr. Chandler received 2 for the first degree sex offenses, and then 21 years for the other charges, all of which is so important to state from the very beginning, never happened. So our contention and our proof shows, our contention is that there was no crime, there was no abuse, just like in so many other cases that arose during that period. It was just a runaway train of allegations.
And I'll get into a lot of that in a second. You know, I just kind of wanted to untease a little bit of this. You know, ironically, the first wrongful conviction case I ever covered, the guy ended up being sentenced to 378 years, and my jaw just dropped because I'm like, why would you do that? It was a serial child rape case, which also never happened. So what are the circumstances? And we'll get into kind of this issue of the 1980s, which is when I was growing up, and I remember the McMartin case really well, and I remember being shocked that they were acquitted. Little did I realize that later in my life I'd be shocked the other way. But you know, what happens to Mr. Chandler here? How does he get caught up in all this stuff? What's kind of the circumstance of the allegation?
I'll take that, and then I will let others take other questions. But the motion for appropriate relief that we filed in the state court to get his conviction overturned really sets out how, in leaving aside the 1980s context that we're going to talk about later, how did Mr. Chandler get caught up in this? And I think it started with just looking at the details of his job. Mr. Chandler was a van driver for a Department of Social Services funded daycare center. So he had kids from 2 to 5 years old on the van. At the same time, he would transport some cognitively impaired adults from a work center, and they're all on the van at the same time. And this is the mountains of North Carolina, so it took about an hour and a half to get everybody home from daycare and home from the work center. But meanwhile, people are on this van together. There's a longer story here, but what happened is that some of the children started to talk about the quote, married people on the bus doing married people things. And the married people on the bus, which is actually a small van, but they called it a bus, the children did, that the married people were 2 of the cognitively impaired adults with IQs between 60 and 68. And they were boyfriend and girlfriend. and they lived in a care home, had been intimate in the care home and had been separated, and sometimes on the van had been intimate there as well. And the children talked about it, and just given the times and given the size of the community and how innuendo and rumor and allegations ripple through, before at the end of the day, the children were saying that they had been molested, abused by those two married people who became co-defendants in this case, and the van driver, Mr. Chandler.
So this is, this sounds a lot like, a lot of these other cases, which is, of course, why in the filings they brought in kind of this moral panic and hysteria during this period about child sexual abuse. And of course, this is also a time when a lot of parents or both parents are starting to work, especially in the 80s. And so they have to leave their kids with strangers. And there was this kind of panic, stranger danger, and the McMartin case and some of these other high profile cases. How does that play into this case?
Well, Theresa, you have to talk about this stuff. You know it better than the rest of us.
Yeah. Why don't you start, and I know this way too much because this is not my first case. What happens, and Jim Coleman will tell you, whatever area of, that are case eyewitness identification or child sex abuse, the press covers it if your client is exonerated, and then we get a flurry of contacts from others. And in fact, though you may be planning to ask me about this later, I'll tell you how we got this case, because it kind of explains my point I just made. We had another client who had a child sex abuse convictions, multiple life sentences, and his case had satanic elements, also from the mountains of North Carolina. But there was levitation in his case. The children alleged levitation and drinking of blood and ropes and fires. And we were successful in having his conviction overturned. The judge got it. And when he was being released and the court was making his ruling, I, as lawyers do, went up to the court to the judge with my co-counsel and thanked him and told, nice meeting you, thanked him. And at that time, because we knew that that client was going to be exonerated, a lawyer in town in Durham, Mr. Chandler's former lawyer, had said, would we take a look at the file in Mr. Chandler's case because his earlier efforts had failed? And I said, I'm an easy mark. As Dave Martin said, he calls me up, I say, yes, we'll take your help. So I'm an easy mark. I told that lawyer, yes, I would look at the case, but we could not take the case because we had a full complement of cases, and frankly, these are exhausting cases. They take a tremendous amount of work, tremendous investigation, and we were just wrapping one up. But I got the files and I was going to look at it, and then fast forward, shaking the judge's hand. The judge is a big person. He's sitting on the bench, and he leans over and says to me, there's another innocent man who needs help.
The judge,
and the judge said that to me, and I said, because I was trying to protect my own clinic's interests, and I said to myself, oh, please let don't say Junior Chandler. I didn't say that out loud. And the judge said, another innocent man from the mountains, and it's Junior Chandler. So then we took the case. Then we had to take the case. My colleagues and I talked about it, but then we decided to take the case. But all of that, so how does that relate back to Hysteria? Both of those cases arose at the exact same period, in the mid to late 80s and the early 90s. And that's when they all arose. I mean, you yourself said, David, that the first case you looked at was something like this, and it probably arose the McMartin, Little Rascals, the New Jersey case. They're all over the United States, and most of them have fallen. Most of them, it has been proven that they were wrongful convictions. It's you said it perfectly. I think that there were all these children were in with strangers, and people were concerned, and they thought predators, the satanic element. There was a belief that satanic predators were roaming the United States, and men, you couldn't leave children with men, and it was a wild time. And I like to believe, and I have said this while representing the prior client and Mr. Chandler, I have said that this wouldn't happen today. But then, quite frankly, we recently were contacted by somebody who's interested in the QAnon conspiracies and tying it back to how this got started in the 80s and the early 90s. So I'm not sure it wouldn't happen today. There's much more that Jonathan Beck, I think his name is Jonathan Beck, wrote a good book that I used when I was trying to wrap my head around, he's a reporter, around these issues, and kind of sets out really how it happened and how people suspended disbelief in these cases. So it just was a moment in time, which I fear isn't completed, though I do believe that Mr. Chandler's convictions that stand are one of the few that stand of these kinds of cases.
Yeah. Oh, go ahead.
Well, what I was just going to add, that it's easy to see that if there's a public allegation, meaning an allegation that gets to the prosecution, to the prosecutor, or to the police, that a child is being abused, I think it would represent the highest duty that the prosecutor and the police had to check that out, to determine whether that's true. And I think politically and morally, they would feel an obligation to protect the children. That's, there's nothing that they can do that would, is more important than that. The problem is that the prosecutors and the police don't exercise any independent judgment in these cases. And they basically just run with it. And the charges keep changing, and they morph into, bizarre stuff, and they're on spaceships, and, and the prosecutor just rolls with that. And eventually, they have to cut it off, and they go to trial, and they present whatever they're left with. And, and that's what happens. Jurors are in the same position though, right? Because, they want to protect the children too. And if they think that there's any chance that something like this is happening, they're not going to let this person go free. So if the prosecutors aren't exercising independent judgment in these cases, the defendant doesn't have a chance.
It is amazing. And I think, having lived, I was in high school in the 80s, so I'm kind of in the middle of the age range of this group. But what's really interesting, thinking back now, is how paranoid the adults were about things like satanic cults and this idea that you were gonna, if you listen to a certain kind of music, you were gonna get sucked in to satanic worship, and I remember some of the, what was it, Geraldo or whatnot, and some of the stuff. I mean, the younger folks here probably have no idea what I'm talking about, but it was very different at that time. But I do want to bring them into the conversation. So maybe John and Meredith, you can talk about how you got involved in this case and kind of what work you guys have done and how that's incorporated into your ongoing education.
Yeah, so I'll start. So last semester I took a class that Duke offers called Federal Habeas Corpus, and it really takes a broad overview of the federal system and post-conviction review. And I really enjoyed that class. And I really learned kind of how even, just a plain worded statute can have really, really big effects on people's lives at the federal level. And so going into this semester, I knew that I wanted to, work and help fix the injustices that we heard about all last semester. So I signed up for this clinic, and then I was put on the Junior Chandler team. And it's been really a great place to work and a great time this semester working. Obviously, the circumstances in which I'm here are less than ideal. I wish that Duke didn't have a wrongful convictions clinic, only because that would mean that no one was wrongfully convicted in prison. But knowing that that's the reality, there's great work that we're able to do. And so I think one of the things that's really stood out to me is, my family and I were big Law and Order fans growing up. And so we'd watch Law and Order, and they always have their token episode about how, they don't know if someone was wrongfully convicted. And the whole episode is listening to the internal battle of the police department, trying to figure out whether or not they accidentally put someone in prison wrongfully. And that was kind of my vision of how wrongful convictions happened. It was this, all the evidence lined up for person A, but out of nowhere, we figured out it was actually person B after 25 years, and everyone feels awful about it. But on my time in this clinic, and my time kind of last semester as well, you really learned that in a lot of sense, that's not really how any of these wrongful convictions happen. And I don't think that's how it happened in this case. I think in some sense, there may have been some foul play and some misplay. We talk about that in our motion for appropriate relief, but it's just one of those things that, as a law student, you walk in with this vision of what the criminal justice system is and what it does. And this seminar and this clinic has been really, really eye-opening to see, what it's like on the ground, and to know that, well, last semester, I was reading out of a textbook. This semester, I'm learning the same thing, but it's a real person. It's a real client who's wrongfully convicted. So just that personable experience and really having to work on this, because it's actually a person in prison, not just a page on a textbook, has been really eye-opening. And it's been great being a part of this team this semester.
Meredith?
Yeah, so kind of how I got involved is I knew going into law school, I wanted to work for the Innocence Project and Wrongful Convictions Clinic. I was on the Innocence Project active investigation team my 1L year, and then lead one this year, and then joined the clinic. And so what kind of motivated me was that phrase, I can't remember who said it, I think it's the Brandeis ratio, where it's better to have 100 guilty people go free than one innocent person be convicted. And I just wholeheartedly believe that. And so that's why I'm kind of passionate about this work. And one thing that I want to bring up that we worked on, and kind of tying it back to this case specifically, and something that's really stood out to me in this case, is something that we just filed as an exhibit, the Van Route affidavit. And basically what that says is that there's not a day where this abuse could have happened given the necessary predicates. And so for abuse to happen, just looking here, the daycare had to be in session, Mr. Chandler had to be driving the bus, the alleged victims had to be at daycare and riding the bus, the co-defendants had to be on the bus, and there couldn't have been anyone else on the bus, some of those mentally impaired adults. That said, abuse didn't happen. And if you combine all of those factors, there's not a single day where abuse could have happened. And that is just striking to me, that if you look at the procedural history of this case, that no one recognizes that, and no one kind of captures like what I say for the case is that it's a totality of circumstances. Just so much went wrong in it, and there's just so much evidence that he isn't guilty, that Mr. Chandler isn't guilty. And it takes me to a quote that we've talked about a lot, in the clinic from Judge Wynn on the Fourth Circuit during Ronnie Long's case, where he just says, and it's personal to me too, because I kind of believe in stare decisis and judicial restraint. But why is it that in these cases we give so much credence, like rely so much on these past decisions? Why don't we look at new evidence, and why don't we consider whether the person really is guilty or not? And so, yeah, that's what I have to add.
I need to jump on to that, Meredith, because as Meredith and John know, but my other colleagues don't, that we quote from Judge Wynn in what we're filing right now in response to the judge's recent order. And what the line I love is when Judge Wynn says, well, a couple of lines, but what makes us so afraid of these cases? Why are we afraid to look at them? And then he repeats several times, when did justice leave the process? This is a federal judge sitting in the United States Court of Appeals for the Fourth Circuit in oral argument in another one of our cases that suffered a similar procedural fate, where there was just our opposing counsel at every turn was obstructed and was, quote, afraid to look at these cases. And judges are inclined in these old cases to bar claims based on procedural grounds. So I really am very delighted that you brought up Judge Wynn.
And I covered actually that hearing where Judge Wynn said that. I was pleasantly surprised to see them end up freeing Ronnie Long. That was an amazing thing to witness. I hadn't actually witnessed one of those personally like that before, so that was really fun to watch. In terms of this case, what's striking to me, I mentioned kind of the procedural history. So why is it that the jurors are hanging and then they end up acquitting him on a bunch of charges? What is it about the original charging that the jury was even skeptical of?
Yeah, he didn't get acquitted of too many charges, but there was there were 7 children in the case. And remember, it hung in a different county, right? So then it was moved to what everyone tells me back then was the more sophisticated county that believed that just about any darn thing could have happened up there in the other county where this case arose. So there was this notion that I hate to, well, there was just a notion that that was a backwards county as compared to Buncombe, the county of Asheville. And but the charges, so one of the children, he was acquitted on the charges related to one of the girl children. And that was this brings up another really important point, but that was the girl who didn't have in which the doctors did not observe the medical they didn't make a medical observation about that girl child that they made about the other 4 girl children, that medical observation that at the time was believed not only diagnostic of sexual abuse, but dispositive of abuse. So the girl child, they didn't see that in that girl child. So they didn't conclude that she was definitely abused, the medical doctors, but that she was very likely abused based on her history. In the medical world, history just means your reports of abuse. It doesn't mean, demonstrated history of abuse. It's reports of abuse. But the other thing about this little girl, I had this note somewhere but she was on the bus she was in daycare and rode the van a very short time. And we do have some of the first trial's jurors' reports, and they were concerned about how short a time frame she was riding on the van. And just because, the very thing that Meredith was talking about, what we call the impossibility defense, right? Was there any day on which the allegations aligned the allegations as made by the state as made by the children, where they aligned to make that a possible day. And for this little girl, there were just so few days, and she didn't have that, that they didn't make the medical observation about her.
Understood. So I'm gonna read a couple of quotes from the filing, which I think are really illuminating, and then I want to get into kind of a deeper dive into the evidence of innocence here. So one is overall more than 150 defendants were initially charged in at least 10 major child sex abuse and satanic ritual prosecutions across the country from 1984 to 1995, and at least 72 were convicted. It's clear that a great majority were totally innocent. And then the second quote is, at the center of many of these prosecutions were well-meaning but misguided healthcare professionals, social workers, and others who were concerned about children's safety, especially given that unprecedented numbers of children were in the care of near strangers at daycare centers. So I think these two quotes are really interesting because a lot of this, there's nothing malicious going on here. They're trying to protect children, but they made mistakes. What mistakes were they making here?
What's so interesting about those two quotes, and there are more like those that we wrote, is that we file our motion, and then the state, the prosecution is ordered by the judge to reply. And we were taken to task for trying to, with those contextual comments, right? The providing the context, explaining how this case arose during that period, explaining that these people were not evildoers, that they were the people who, the medical doctors, the social workers, they were all, I believe, with one exception, well-intentioned. And but we were criticized in a filing by the state for trying to prove innocence by association, meaning that Mr. Chandler is innocent, as if that was all we, I did notice this morning that there's 40 pages of setup to this 100+ page motion, but the 40 pages of setup is so important because the context is so important. You have to, in all of our cases, and this is what Jim Coleman always tells our clinic students when we start the semester, when we first start an investigation, we assume the person is innocent, and then, because they're claiming innocence, we say, okay, well, if that's true, how did this happen? How did the allegations arise? How did the person get convicted? So that's what we were doing in this motion for appropriate relief. We were providing the necessary context for the judge to understand how an innocent man was ensnared by the times, by the beliefs of the times, by the medical science of the times, the psychological science, and you have to include that. So, and the first quote is the numbers quote that comes from the National Registry of Exonerations, I believe, which is an organization that tracks exonerations of all crimes, and so those numbers are correct, I believe.
Maurice will be glad to know that.
Maurice has hounded us after each one of our, Maurice Posley, a Pulitzer Prize winning journalist who now lives in California, and I don't know what his role is in the registry now, but for years was the person who wrote the summaries and made sure the numbers were correct, and hounded all of the lawyers across the United States for the data on our cases. So we know Maurice well.
Yes. But I want to get back to kind of my question, which was, what went wrong here in terms of, this prosecution? What is the evidence for innocence? You know, kind of the broader question. Maybe we can bring the students in since they've been researching this. You know, what jumps out at you? I mean, you know, what's kind of the bullet point that you say, oh, he's definitely innocent? You know, what do you hang your hat on there?
Yes, I'll go first really quickly. So Meredith and I have actually, I would think there's kind of two main things to me that stand out for him being innocent. And the first is a litany of things that we allege the state withheld or didn't disclose before trial that they're constitutionally required to. And those are a number of things between adult passengers saying nothing happened, people who lived in the area saying nothing happened, but really what stands out is the fact that a number of medical experts testified at trial, and a number of social workers did as well, to a number of summaries that they had when they were interviewing children. And so the summaries kind of attempted to lay out what happened, but it's very clear that the summaries were not actual highlights of what happened at the interview. And so I don't have any specific examples in front of me, but you know, the summary will lay out what looks like a child clearly saying that Mr. Chandler did something. But then when you actually look at the transcript, what it was the kid saying nothing or even denying the charge. And then the interviewer constantly giving leading questions, constantly asking again and again, asking, you know, oh, but where did Mr. Chandler do it? And, you know, when I'm reading over the differences, it's really, really stark, because if you read the summaries, it tells one story, but then you read the actual transcript that the state didn't disclose until well after the trial was over. And you're left with the sense of shock of, you know, I can't believe they testified to this at trial, because that's just not what happened. And then the other thing that is really the impossibility chart that we mentioned before. If you see it, it's really powerful just to see how every day falls off and off and off. And then you're left with just a number of months that this could have never happened. And, you know, we're reading the chart, and if the state were to rebut it, it would require them to possibly, you know, say one of their witnesses wasn't being truthful on the stand, or, you know, say that the kids were there when the evidence clearly says they doesn't. And so, you know, it's one thing, and, you know, Professor Newman calls me the team skeptic, and I'm always thinking about what the state could say. But even I, when I read this chart, I was just kind of taken aback, saying, you know, there's no way. You know, I'm always trying to think of, oh, what would the state say so we can jump ahead of that. But I was really just left in shock with, you know, the research that we all did and what the chart says.
And
Can I add one thing?
Go ahead,
David, just one thing and so important. I think everyone is really to agree with John when they read the difference, the interviews, the actual recorded, transcribed, actual recorded interviews of the children, and then the summaries. The summaries actually were called, they were prepared by the social worker who interviewed the children with the doctors, and sometimes without the doctors present. And they were called highlights. She said they were highlights, and they would look like transcripts. So they'd have the child's name, and then they'd have the doctor's question, then the child's name. And those were what they and they were indeed highlights. They were highlights for the prosecution. They were, in some cases, we proved, and because we finally got the interviews later, but we proved that pages would go by where the child is either completely denying any abuse, is denying Mr. Chandler was involved in the abuse, is inserting fantastic elements, like fantastical, not great, but fantastic elements of fantasy. And that, but the highlights, the summaries John's talking about, they go straight to, and like, so I asked her, did somebody hurt you? She says, yes, Junior did. What did he do? He did this. And it's like pages of suggestive, persistent interviewing, repeated denials until you get that.
So how is the state responding to your claims?
So there's a whole, so first I'll just say that there's a whole litany of medical evidence that's now just proved that Meredith did a lot of research on. So I'll kind of reserve that and how the state responds it until she gets a chance to respond. But as far as the withheld evidence goes, so, you know, the basic outline of a Brady claim is that it has to be withheld, it has to be material, and it has to be beneficial. And so the state first they always put up in bold letters, this is procedurally barred. If they can win on that, then they don't even have to touch the merits, which in my opinion aren't great for them. But, they always put the big neon sign that says, don't worry about the merits of the case, worry about, the procedural bar. And so the state uses a number of arguments. They say, you should have brought this up before, or you had some weird version of this at trial, or it's not favorable at all. But for example, there's one part where the state says you have one person who denied anything happened that day, and our evidence is that 2 other people denied anything happened that day. And I think it's a curious argument to say that there's no difference between one person saying something didn't happen versus 3 people saying something didn't happen. And so, I think the state is willing to pull every punch they can to make sure that our MAR gets denied. But really, I think it starts first with procedural bars, and then it moves down to, oh, this isn't material, or oh, this isn't exculpatory. But I think what's rather unique is that as far as the impossibility chart goes, the first motion for appropriate relief that we filed, mentions it not very explicitly, but it says that there's very, very few days that this could happen. And the state says nothing about it. And then we file an exhibit that very clearly says there's not a day that this could happen. And we have still yet to hear a word from the state on that. And so we even say in the MAR that the state might have even started investigating it, but abandoned it. And I think it's very interesting how, kind of through all of this, the state has been so willing to pull every argument out of their hat to make sure that this motion for appropriate relief gets denied. And yet, basically what could be the ace in the hole, they haven't touched once. And so I think it's rather telling that the state in all of their filings hasn't said anything other than one small statement about it was available to the defense before trial.
And let's bring in Meredith here to kind of address the point that you just made about the medical evidence.
So basically the state addresses the medical evidence and even the judge in the most recent order by saying the basic underpinnings of the research were there, even if not in their crystallized form. And that's an exact quote from the judge's order. And I think that's kind of wild because how was the previous attorneys in this case supposed to rely on something that wasn't in their crystallized form? Just because kind of a theory of science that was going around in the 1980s was raised, that's different than now known today to be false medical testimony. What was testified to at the trial by those doctors, they would not be admitted as experts today to testify on those same things because the medical evidence is not supported anymore. I mean, it's false. And so that is the response from both the state and the judge, but we could test that. And then to go back to kind of the highlight summaries that Professor Newman was talking about and John, I think the percentages of how much the children spoke versus how much the interviewers and doctors spoke is also really wild. So just to give you an example, in one of the children's interviews, there were roughly 6,000 words spoken during the full interview, and only 7% of those words, only 400 words, were from the child themselves. So just looking at how suggestible these interviews were, and exactly like what Professor Newman and John said, it's like a totality of circumstances case. There's so much going on that it's sad that the state continues to respond to these claims and kind of deny the evidence that we've presented.
And Dave, if I may add at this point something that Meredith just brought up regarding the children's interviews and the numbers of words spoken or responses from the children. So the child, may have responded with 400 or so words out of 6,000, but many of those words, many of those responses were, "I don't know," "Junior didn't do it," or in fact stated other people had committed the sexual abuse. So as you look at these transcripts and then certainly compare them to the summaries from which the doctors testified, it is substantially different. And those summaries in no way include any exculpatory information or any denials or any hesitation on behalf of the children, pointing toward hesitation and saying Junior did it.
Can I just, I mean, that is the stunning thing. And we kind of just did that. This is the beauty of having a clinic with student assistants. Before we filed the MAR, when we were looking at the interviews, we said, who's doing the talking here? So we just said, I mean, I am so cruel. I said, could somebody count the words? So they counted all the words and divided up and then figured out the percentages. And then when I talked to Dr. David Mantell from Connecticut, who is a child sex abuse forensic psychologist for the state, he said, that's actually a common forensic technique in child sex abuse cases, child interviewing, to figure out who's actually doing the reporting of the abuse. You look at how many, who does the talking, who's doing the bulk of it. And the one that we included, I mean, I think we included all of the numbers in the motion, so you would have seen that, David. But one of the children, it was 1,156 words. It was a short interview, 1156, 11, if I can read what I have on my screen, 1123. So 1,156 spoken words during the interview, 1,123 were by the adult interviewers. So 33 words, and keep in mind what David said about what those words were. But I think it's really important to go back to the medical evidence, because I think the medical evidence and the time in which this case arose is really what set this case off, put the train on the wrong track. It was believed at the time by the medical community, by doctors. It was believed, but it was an assumption because it wasn't based on research, it wasn't based on science, but it was believed, and I'm sorry to say this in polite company, I've talked about such things, but if a little girl's, a female child's vaginal opening was larger than 4 millimeters, that it was diagnostic of abuse. So other than that one child that I told you, Junior was acquitted of, the other 4 girl children, the doctors said they saw that the vaginal openings were 4 millimeters or larger, and therefore diagnostic of abuse. They concluded that these girl children had been abused. Why? I mean, that's today. And it's because of all these crazy cases that arose during this period, researchers got really interested in, is that true? Why are we saying this? Is this true? And they did this research that Meredith was alluding to or referencing. They did this research and determined, oh my goodness, there's wide variability in the size of these openings. Now, lawyers are lawyers because somebody will tell you they're not good at math, they're not good at science. That's not always true. But I wasn't quite sure what 4 millimeters was, what that looked like. So we had another student develop with an engineer, develop a graphic that is in the motion for appropriate relief that shows relative to, I can't remember the coins that were used, but like a quarter and a nickel or something, how tiny, how truly tiny 4 millimeters and then 5 millimeters is. I think it goes 1, 2, 3, 4, 5 and up. And these doctors said they eyeballed these openings in these children. They testified that they're tiny. They testified that they may have had a ruler in the room, but they didn't necessarily use it. This man has been in prison for 34 years on the basis of their observations, which are, of the size of these little girls' vaginal openings, that now, introituses, I think is the actual medical term, and they didn't use. So, okay, well, leave that aside for a moment. What we know today is that medical evidence is bogus. It's false. It doesn't support a finding. It is not diagnostic of sexual abuse. But in 1986, when these children were being interviewed, and in 1987, when Junior was being convicted, they justified persistent questioning because under another belief at the time, the child sexual abuse accommodation syndrome, it was believed that children were reluctant to divulge. They were embarrassed, they were afraid, they were intimidated by their abusers, so they were reluctant to divulge the details of abuse. So once you believed they were abused on the basis of the medical, now discredited medical evidence, it justified any means you could use, short of torture, I believe, to elicit the particulars of the abuse from these children who, and I don't think we've said this yet, were 2 years old to 5 years old. I think there were two 2-year-olds, 2 3-year-olds, 2 4-year-olds, and 1 5-year-old. I think that's right. They were, one was pre-verbal, one had significant speech impairment that you couldn't understand him. These were little children. And they were persistently, repeatedly questioned, not in single interviews, in multiple interviews, until these highlight summaries were created that were, you know, again, these people believed these children had been abused, so they did what they could to prosecute the people that they believed to be, they concluded were the abusers.
I'm really fighting the urge to do the face palm right now. I gotta tell you. Yeah, no. You know, so basically this is junk science. You know, which you know, they had an assumption. It wasn't scientifically tested. It's like Brandon Garrett's book that just came out, and they used that as the basis for the underlying belief, and then they tried to sculpt the victims, quote unquote, testimony or descriptions to fit that narrative. Is that a fair summary? So I want to ask you, Jim, this question, even though I kind of know the answer to it, but I think it's a really, it bothers me a lot as somebody who covers this stuff. You know, what John was describing was all of these procedural barriers that the state is putting up. You would think that the state would want to find out if they have incarcerated a person wrongly, and that they would be more interested in justice than arguing, oh, well, this issue's already been raised. You know, I mean, I think that's what a layperson would argue, but that's not what happens. Can you comment on that?
Well, that's not what happens at all. You know, and prosecutors and attorney generals, you know, they run around the state and they talk about, you know, being, you know, officers of justice, and, you know, their role is to seek justice, you know, that the state wins when justice is done and all of that. In fact, you know, once they get a conviction, they have no interest at all in whether, in fact, the person was guilty. And we see this all the time. We have prosecutors who will absolutely ignore every fact that we present to them and simply rely on some procedural issue, some procedural bar in order to defend the conviction. We've had prosecutors who've said to us, you know, we think this guy is probably innocent. We don't believe he would have been convicted today. I know he wouldn't have been convicted if I had represented him, but my obligation is to defend the conviction on any grounds that it can be defended on. And when we run into a prosecutor who takes that view of the job, a minister of justice, you know, we get a case like this. On the other hand, when we, you know, when we find a prosecutor who's actually willing to ignore the procedural defaults or not to raise them and focus on the fact, you know, we've had a number of our exonerations have been the result of prosecutors who look at the facts and they conclude that we're right on the facts, you know, and so their view is, as a minister of justice would, that this person shouldn't be in prison. The person is innocent. the problem is we don't have that many prosecutors and attorney general who take that approach to their job.
I just, you know, to me, that is the most baffling part of all of this wrongful conviction problem that faces this country. I get how mistakes are made.
Right.
That makes sense, especially, you know, when you have people that may think that they know what happened and they really didn't. But, you know, not wanting to correct the mistakes, you know, this guy's been in prison since I was a freshman in high school and I'm almost 50. So, you know, that's a problem.
And I want to just build on what Jim said to say, back when Jim and I first started the clinic, we had different responses from, and we still occasionally get it from the DA's offices. But one of our cases, Lamont Armstrong was one of our clients. He was exonerated in 2012. But when we presented to the DA's office, to the elected district attorney and his chief assistant district attorney, we always, when possible, present the case to them before we file. He said, the chief assistant said, just what Jim said. You know, I see that we are not, these are very serious constitutional claims you've raised. We are not going to raise any procedural bars that this case deserves a hearing on the merits. All of the claims deserve a hearing on the merits. The hearing date was set and we proceeded to prepare individually. And 2 months before the hearing date, I received a phone call, and it was from that assistant district attorney. And he said, first he said, "How are you doing? You enjoying your summer?" I'm like, why is he calling me? He's not my friend. But he said, while they were preparing for their hearing, the detective who was helping him prepare re-investigated and reran some of the forensic evidence in the case and solved the murder. And it was a different perpetrator, that our client had spent 17 years in prison for crime he did not commit, and only because a prosecutor was interested, and a detective, kind of an extraordinary detective, was interested in cold cases and wanted to learn about them, he solved it. And they expedited the hearing and released our client. Now that can't happen in this case because no crimes occurred, but the attitude, the approach, and it was like that in this case. When I first talked to the assistant district attorney on the other side, he was very interested. He wanted to talk to our expert, who is 99% of the time is an expert for the prosecution in the state of North Carolina. But on these cases, she wants to correct the injustices that occurred before the science caught up with itself. And so she gave us a really good report, and he wanted to meet with her. But then something happened between that point. He never met with her. And I encouraged him. I said, I don't even need to be there. Meet with her. But between that expression of genuine interest and the date that we received the response, the official filed response to the motion in the case, it was a sea change. And one reason for that, we believe, is we later we figured out, and it was confirmed, that he actually didn't write the response. He had the assistance of the Attorney General's office that wrote the response, which was quite different from what we were expecting in the case, and you know, tragic in my opinion.
So what do you see as the prognosis in this case at this point?
Well, I mean, you know, we're not going to make a prediction about what the judge might do. But you know, what we tell our students in the clinic is that we never give up, ever, never give up. So we believe he's innocent, and we will figure out how to prove it. And if it doesn't happen in the superior court, we'll go to the next court and the next court until eventually, we convince somebody to focus on the facts. And when they do that, they can't defend the conviction in this case. We tell our students in the clinic that when a wrongful conviction happens, the first thing we have to do is figure out how it happened. And then the second thing we have to do is to look for the loose threads that will allow us to unravel it. Because it's not a smoking gun. It's much more subtle than that, which means that, the prosecutor and the attorney general have to be willing to look at the threads and not, pretend that, you need a smoking gun in order to demonstrate that somebody innocent was wrongfully convicted.
And Theresa, I have one other question. You said that this came to you and the judge told you that there was another innocent person. How did he know? And I mean, I'm just flabbergasted that a judge would say that because that's just like, you don't hear that.
No, not usually. He knew it, believed it, because he had been a defense lawyer at the time the case arose, and had been approached by the family, but more importantly, he followed the case, knew what the case involved, was a student of the times. He always believed, he knew Junior Chandler, doubted that Mr. Chandler could have done this, and then saw the evidence and didn't believe it. I'm making he didn't tell me why he believed it, but I know who he is, where he practiced, how he touched this case, and I know him from the other case. He understood how these cases came to be. He understood, sort of the hysterical impetus for these cases, and that once, as Jim Coleman pointed out, the impulse is to protect these children. I have a 4-year-old granddaughter. If I thought she had been abused, every fiber of my being would be to protect her, to find out what happened. But I'm also, because just like the good judge who said he was innocent, I know what leads to false reports. And I caution my nieces who have young children not to laugh when the child tells the teacher that mommy went out of town this weekend and left me home alone and I ate popcorn and hot dogs all weekend. I said, because don't laugh, because it's important to tell them you have to tell the truth, because those stories get believed. The other part of the tragedy, David, we haven't talked about is Pam and Buddy. Pam and Buddy were the married people on the bus. They were charged as well. They could not comprehend what was happening. Pam, we now know, was like when she was questioned about it, said, I don't know, are you talking about boys, girls? She didn't even understand what was happening, but their lawyers represented them. No guardians were appointed to kind of protect them from lawyers' our impulses to get the best deal we can for our client. Very quickly, those lawyers got truthful testimony agreements, plea deals, that they would testify truthfully in a trial against Junior, and they both had received no active jail time. But they were, when these highlight summaries were prepared, they were prominent in the summaries. And actually, when you look at the full interviews, it's a lot about the two of them and what they were doing on the bus, and they were taking each other's clothes off. But the tragedy is that and the third tragedy, I mean, it's just the ripple effect. is these children have grown up believing that they were victims of horrible abuse. And we haven't talked about the specific allegations very quickly involved being put on a Mr. Chandler driving this van with kids and Pam and Buddy in it to the riverside, 2 different locations at the riverfront, putting them on boats and abusing them out on boats, doing all kinds of horrible things with, to them. And these children have grown up believing it because they were 2 to 5. They were too young to really have reliable, those are their memories. They were told, they testified in 2 trials, most of them. They were told, they were repeatedly interviewed. They were rewarded when they received letters of support when they were afraid to testify from well-meaning people around the nation who were part of Mothers in Action or the Believe the Children movement, these nonprofits that sprung up. And it just was a really unprecedented time, though we're seeing some of it today, as I said, but an unprecedented time that victimized so many people. Mr. Chandler down to the youngest child in the group.
And then kind of my final question, and I'm hoping maybe the students can answer this one, but how do you guys decide what cases to take, and what's kind of the what are you looking for when you decide to take on a case?
That's a better question for Jim Coleman, but I'll let Meredith answer it. But they don't. I adore these students and they're great, but they don't decide which cases.
No, I understand.
No. I was just going to talk about the Innocence Project a little bit, since I kind of had both sides, and then let Professor Coleman answer. But from my experience, and again, like Professor Newman said, we don't pick the cases. But for the Innocence Project, we kind of get the initial review of the case sometimes. And so we'll start by the framework, okay, is this person actually innocent? So we will think like they are guilty. How do we show that they are innocent? And so we'll go through the case. And if we think and believe and the evidence supports that the person is innocent, then we'll kind of flag the Wrongful Convictions Clinic. That's the experience that I've had with it, but turn it over to Professor Coleman.
Well, that was good.
Jim's getting the actual answer from somebody else.
No. Actually, I just had a phone ring. Well, what we do is, because we generally don't have cases that have DNA, so we're looking for the equivalent of, DNA in non-biological evidence. And what we do is to look at the factors that have led to wrongful convictions, factors that are set out in Brandon Garrett's book, for example. And we look for those factors in cases where people write to us and say that they're innocent and they want us to investigate their cases. We turn down most of the cases of people in prison who ask for our help. But when we find a case where the person is claiming actual innocence, had no role in what happened, and there's no forensic evidence, no physical evidence that links the person to the crime, and we find one or more of the factors that contribute to wrongful convictions, false confessions, eyewitness identifications, misconduct by the police, misconduct by the prosecutors, junk science, then those are the cases that we are more likely to take. And then the last step is that we have to find some way that we think we can prove innocence, right? That there is some route that by which we can demonstrate that this person is innocent, because we're proving a negative, right? And that's sort of the beauty of, John and Meredith referred to the impossibility chart the exhibit, but that's the beauty of it, because it's one of those occasions where we actually prove that we prove a negative, right? We prove that it didn't happen because it couldn't have happened during the period that they said it did.
All right. And then I guess maybe everybody can kind of go around one more time and just give kind of your final thoughts here. We only have a few seconds left, but let's start with Meredith.
Yeah, well, again, just thank you for having us. And the last thing that I wanted to bring up is just more about Mr. Chandler himself. So like we've said before, he was 29 when he was convicted, wrongfully convicted, and he will turn 64 in September. So he's been in jail longer than John or I have been alive. His sons were 7 and 3 at the conviction, and now they're 40 and 36 roughly, with children of their own. His father passed away. He contracted COVID-19 in jail. This story is it's really sad. Like Professor Newman said, there's so many victims in this story. And I would just like emphasize the human aspect here, and Mr. Chandler sitting in jail for a crime that he did not commit.
And John?
Yeah, just to echo the same thing. I think this whole case really has taken, the law and the practice of it, out of a textbook and, made it personal, because I think, a lot of law school or what you read on the news, you don't really think that that's a person. It's just a story you read or something you see. And it's been really eye-opening to know that, we're working on work, and we're really working to bring justice to a scenario where there really hasn't been any since the 1980s. And so it's been a delight to be here. But the circumstances are just really heartbreaking. And that's why we're doing the best we can to help right the wrong.
And Dave, your thoughts?
I think both of them said that very, very well. This is certainly a different area and a different practice and different outcomes and concerns and effects on people than my commercial practice. You read the motion for appropriate relief, and I encourage people to do that in page after page after page after page of clear errors, clear lies, and bad science, and it is heartbreaking. I think as John said, but these are real people, real lives that have been destroyed by these wrongful convictions.
Jim?
Well, when throughout my career, the one thing that I've always wanted on the other side of a case that I litigated was an honest lawyer. I have a quote from Abraham Lincoln in my office about, if you can't be an honest lawyer, then choose some other profession. And I think that that's often what it comes down to in these cases, when we have lawyers on the other side who are not indifferent, who care about whether or not an innocent person is in prison, who's honest about reviewing the facts, then we have a chance to remedy an injustice. And I think too often we have people who are indifferent and people who are, as a result of being indifferent, are not honest lawyers.
And Theresa, I give you the last word.
My last word is really, I want to thank you, David, for giving us this opportunity. And what it's just a mixture of emotions for me, tied in all about the case and where the case stands right now. And I'm not sure we told you that, but the judge has issued an order denying 5 of the 7 claims and has invited us to brief the last 2. So we are working on more than just briefing the last 2, but that's where it stands right now. And they were denied on procedural grounds. So that's the great tragedy. But the other thing I want to say is that having an opportunity just to be in an interview, or to be with my colleagues working on the same case when they were being interviewed by someone else, and hearing how the case has touched them, how they think about justice, and how they think about what needs to be improved moving forward is just inspiring. And I don't know if you noticed, but as people were talking, I was taking notes to add to my long list of inspirational statements people have made. So I want to thank them for being part of the team and for, you know, it's so much easier to do this work when you have really good people working with you. So, and when you have people interested in the story, David, like you are. So appreciate that.
Well, I want to thank you all for coming on and sharing this amazing story and kind of depressing story. But unfortunately, this is, in fact, reality. It's real people, real lives. I think, you know, sometimes when I talk to my students and send them into court, I always remind them that they're leaving the college bubble and they're going into the real world where real people are facing real problems in their lives, which I think is always important to remind students of. And this is a good reminder for me as well. This has been Everyday Injustice. We've been talking with the Duke Wrongful Conviction Clinic on the case of Junior Chandler, who was convicted in 1987. As I mentioned, I was a freshman in high school in 1987, and now I'm nearly 50. So that's how long that is. Join us again next time for more tales from the injustice system.